Hello, good morning, everyone. So I hope you can all hear me well. No, for the meantime, I have turned off my video so that we can have a we will have no interruptions, especially that I currently have limited internet connection in my location. So our topic for today is Republic Act number 11479, which was enacted in July 3 of 2020. It is an act to prevent, prohibit, and penalize terrorism, thereby repealing Republic Act number 9372, otherwise known as the Human Security Act of 27. So, uh, I'm not sure if you already know about the Human Security Act. So it also refers to the apprehension of persons who are found to be uh participating in terrorist activities. So I hope that you've read about it, but just in case, it doesn't really matter now because as of now, the said law is already repealed. Okay, so we already have a new law, which is 11479, which is known to be the Anti-Terrorism Act of 2020. Okay, so actually, during the enactment of this law, there were so many contentions about this. So, especially on human rights pertaining to our Bill of Rights. Okay, however, there are only two provisions to which the Supreme Court declared to be unconstitutional, to which I will discuss a little later. So this law is valid. No, as of now, the law is valid, and there were only two provisions or two aspects of its provisions which were declared to be unconstitutional. So Section 2, Declaration of Policy. It is declared a policy of the state to protect life, liberty, and property from terrorism, to condemn terrorism as inimical and dangerous to the national security of the country, and to have welfare of the people, and to make terrorism a crime against the Filipino people, against humanity, and against the law of nations. In the implementation of the policy stated above, the state shall uphold the basic rights and fundamental liberties of the people as enshrined in the Constitution. So that's why later you will understand that although on the onset, there were so many contentions about this regarding the violation of the constitutional rights, especially on the Bill of Rights, you will realize later that there are actually securities within the law itself, okay, that will that will prohibit law enforcement agencies from abusing their power as provided for under the anti-terrorism law. So we will examine them one by one. The state recognizes that the fight against terrorism requires a comprehensive approach comprising political, economic, diplomatic, military, and legal means, duly taking into an account the root cause of terrorism and our criminal activities. Such measures shall include conflict management and post-conflict peace building, addressing the roots of conflict by building state capacity and promoting equitable economic development. Nothing in this act, take note, shall be interpreted as a curtailment, restriction, or diminution of constitutionally recognized powers of the executive branch of the government. It is to be understood, however, that the exercise of the constitutionality, constitutionally recognized powers of the executive department of the government shall not, take note, how it is within the policy of this law that the executive department, the power to enforce laws shall not prejudice respect for human rights, which shall be absolute and protected at all times. So within itself, as you can see, even the policy, the declaration of policy of the law itself already adheres, no, already aims to adhere and to maintain that the respect for human rights and to consider us to be absolute and to have it protected at all times. It's even on the intro itself, no? So what is terrorism? How do you define terrorism? Subject to Section 49 of this act, terrorism is committed by any person who within or outside the Philippines, regardless of the stage of execution, take note, regardless of the stage of execution, And you would know also that proposal, no, proposal to commit terrorism and conspiracy to commit terrorism will now be punished under this special law, no, special penal law. So, engages in acts intended to cause death or serious bodily injury to any person or endangers a person's life. Okay? Engages in acts intended to cause extensive damage or destruction to a government or public facility, public place, or private property. Engages in acts intended to cause extensive interference with damage or destruction to critical infrastructure, develops, manufactures, possesses, acquires, transports, supplies, or uses weapons, explosives, or biological, nuclear, radiological, or chemical weapons, and release of dangerous substances, or causing fire, flood, or explosion. When the purpose of such act, by its nature and context, is to intimidate the general public. So the general purpose of this ABCDE is to intimidate general public or a segment thereof, create an atmosphere of or spread a message of fear, to provoke or influence by intimidation the government or by any international organization, or seriously destabilize or destroy the fundamental political, economic, or social structures of the country, or to create a public emergency or seriously undermine public safety, shall be guilty of committing terrorism and shall suffer the penalty of life imprisonment without the benefit of parole. Take note. So you cannot apply for parole in the same way that you cannot also apply for the good conduct time allowance, because terrorism is considered to be a heinous crime. Okay? So, as amended, otherwise known as the Revised Penal Code, provided that terrorism as defined in this section shall not include advocacy, protest, dissent, stoppage of work, industrial or mass action, and other similar exercises of civil and political rights which are not intended to cause death or serious physical harm to a person, to endanger a person's life, or to create a serious risk of public safety. So, the acts of terrorism does not actually include protests, no, advocacies, dissent, no, or if the company is unionized, there's a union, no, they have collective bargaining, stoppage of work. So when the union and its members decide to stop working or stop work because they are dissatisfied, or um the company or the employer refuses, no, na di rin nasugod to collectively bargain, because collective bargaining is a constitutional right. But anyway, that's under labor laws, no, or industrial or mass action. Nagpipiket nga nila at mga workers kay di rin nila satisfied, or di rin nakikibargain, di rin na support and company. That does not immediately constitute terrorism, because at the end of the day, to be considered terrorism, okay, to be considered terrorism, A, B, C, D, and E, the sole purpose of each of that act should be is to intimidate the general public or a segment thereof, and to create an atmosphere or spread a message of fear, to provoke or influence by intimidation the government or any international organization, or seriously destabilize or destroy the fundamental political, economic, and social structures of the country, or to create a public emergency or seriously undermine public safety. So, kung nadilang present, no, engages in acts to cause death or serious bodily injury to any person, or endangers a person's life, but the intent was not actually to cause or to destabilize or to cause fear among the general public, or to destabilize the government, then uh, if a light available, then of course it's serious physical injuries, no, not terrorism. engages in acts intended to cause extensive damage or destruction to a government or public facility, public place, or private property. So, yun nga, if what I an intent, there is no such intent to cause fear or to create an atmosphere of fear and to provoke or to influence or intimidate the government, then that does not constitute terrorism. So, this provision here, this one should be there, okay, for it to be considered as terrorism. Threat to commit terrorism. Any person who shall threaten to commit any of the acts mentioned in Section 4 hereof shall suffer the penalty of imprisonment of 12 years. So here, this does not use the nomenclature, diba? As discussed before in our criminal laws, nomenclature nga ni of the revised penal code, of course, an arresto mayor, arresto minor, reclusion perpetua, reclusion temporal. But here, the 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 penalty is very specific. Thou shall suffer the penalty of imprisonment of 12 years. So, what does it mean? Islaw is also not applicable to the anti-terrorism law. Okay, so violators of the anti-terrorism law. So, planning, training, preparing, and facilitating the commission of terrorism. It shall be unlawful for any person to participate in the planning, training, preparation, and facilitation in the commission of terrorism. Possessing objects connected with the preparation for the commission of terrorism, or collecting or marking or making documents connected with the preparation of terrorism. Any person found guilty of the provision of this act shall suffer the penalty of life imprisonment without the benefit of parole and the benefits of Republic 10592, which of course is your good conduct time allowance. Okay? So I hope that is clear. So because nga this is a heinous crime, terrorism, even it's considered to be a violation of the law of nations. It's a transnational crime because terrorism does not only exist in the Philippines, but it also exists in all parts of the world or in other parts of the world. So, yun nga, if a person is found to be possessing objects connected with the preparation for the commission of terrorism, so you are preparing flyers for recruitment for terrorism purposes, then that person could be found guilty of the violation of this act. Okay? So, yun nga, 12 years. So, conspiracy. So remember, in the revised penal code, conspiracy is only punishable if it is for conspiracy to commit sedition, treason, and rebellion. However, for the special law terrorism, conspiracy is also a punishable act, no, or is already punishable because conspiracy is still, there's still no overt act. No, you're just conspiring or confederating to commit terrorism, but there was no act executed yet. So, the act is still within the mind of the person who wants to perform such act. But at the end of the day, for Section 7 of the anti-terrorism law, any conspiracy to commit terrorism as defined and penalized under Section 4 of this Act shall suffer the penalty of life imprisonment without the benefit of parole and the benefit of Republic Act 10592. No, so it's already conspiracy. How much more? No, terrorism itself. Conspiracy to commit terrorism is already punishable by life imprisonment. But when we say life imprisonment, the maximum penalty of that would be 40 years. There is conspiracy when two or more persons come to an agreement concerning the commission of terrorism as defined in Section 4 hereof and decide to commit the same. So they've already come into the agreement. They've decided that, yes, let's commit terrorism for purposes of destabilizing the government. Although if there is no overt act yet, but they have already agreed that they will commit terrorism, then that is already punishable with life imprisonment. Also, proposal to commit terrorism. Any person who proposes to commit terrorism as defined in Section 4 hereof shall suffer the penalty of 12 years imprisonment. Okay? So, yun nga. The proposal is there. So, wala pa nga ni mag-agree, another person, proposal pala hiya. Diba? So, 12 years that penalty ito. So, masing ka mo, tara, sunugon natin iton San Juanico Bridge para mag-collapse itaton government, para magkalilisang it mga tao, walay nahira. trust sa ating government. So that's already a proposal. But if the person you're talking to accepts that, and that person will say, yes, tara, sunugon naton, then that's already conspiracy to commit terrorism, and that's already punishable by life imprisonment. Pero kung usa pala, no, it's still a proposal, it was not yet accepted, 12 years. Inciting to commit terrorism. Any person who, without taking any direct part in the commission of terrorism, shall include others to the execution of any of the acts specified in Section 4 hereof, by means of speeches, no, proclamations, writings, emblems, banners, or other representations tending to the same end, shall suffer the penalty of imprisonment of 12 years. Ma'am, before kasi, there was before, I knew someone who received actually a letter in writing coming from a leader of the National People, New People's Army. It was in writing, and they were saying in the writing, sub that leader was saying that, um thank you for joining us. Thank you for loving your country, and I hope that you will continue to join us sa aming pag-aakla. So something to that effect. Patuloy nating i-destabilize ang gobyerno para mawala na ang nag-aaring uri. Something to that effect, no? So I did not memorize the letter, but I was able to see from there that really they are inciting persons, no, through patriotism. They are inciting some persons to go against the government, to to abandon their allegiance to the government, and to join the New People's Army in their cause. Sabi nga, to destabilize the nag-aaring uri. So I don't know what they mean by that, nag-aaring uri, no, but yes nga, now if there are persons, no, would say, oh, join the National People's Army, the New People's Army, join this terrorist group so that we can provide more benefits to people, blah blah blah, then those people, those making such pronouncements could be held liable for imprisonment of 12 years. But take note, the law is not retroactive in application. It's prospective, no? Prospectivity, 'di ba? So, any person, ang mga previous nga maang mga inciting to terrorism, they are not simply, covered by this law, because this law only covers acts that were done from July 3 to 2020 onwards. Not retroactive, it's prospective, okay? So, recruitment to and membership in a terrorist organization. Any person who shall recruit another to participate in, join, commit, or support terrorism, or a terrorist individual, or any terrorist organization, association, or group of persons prescribed under Section 26 of this Act, or designated by the United Nations Security Council as a terrorist organization, or organized for the purpose of engaging in terrorism, shall suffer the penalty of life imprisonment without the benefit of parole and the benefits of Republic Act 10592. Well, it's the same, recruitment. So, what is recruitment? The same penalty shall be imposed on any person who organizes or facilitates the travel of individuals to a state other than their state of residence or nationality for the purpose of recruitment, which may be committed through any of the following: recruiting another person to serve in any capacity in or with an armed force in a foreign state, whether the armed force forms part of the armed forces of the government or that foreign state, or of that foreign state, or otherwise. Publishing an advertisement or propaganda for the purpose of recruiting persons to serve in any capacity in or which with such armed forces. Publishing an advertisement or propaganda containing any information relating to the place at which or the manner in which persons may make applications to serve or obtain information relating to service in any capacity in or with such armed force, or relating to the manner in which persons may travel to a foreign state for the purpose of serving in any capacity in or which with such armed force, performing any act other act with the intention of facilitating or promoting the recruitment of persons to serve in any capacity in or with such armed force. Mamay, nag-recruit ka pagod din mga taga-ibang bansa, mga expert, mga bomb expert, no? So, yun. Again, what's the penalty for that? You go back to the previous one. Wait lang. You go back to the previous. What is the punishment for that? Shall suffer the penalty of life imprisonment without the benefit of parole or the benefits of the good conduct time allowance. Any person who shall voluntarily and knowingly join any organization, association, or group of persons, knowing that such organization, association, or group of persons is proscribed under Section 26 of this Act, or designated by the United Nations Security Council as terrorist organization, or organized for the purpose of engaging in terrorism shall suffer the penalty of imprisonment of 12 years. So if you just voluntarily join, you were recruited. The recruiter, life imprisonment. The recruited is 12 years imprisonment. Foreign terrorists. The following acts are unlawful and shall suffer the penalty of life imprisonment without the benefit of parole and the benefits of Republic Act 10592. For any person to travel or attempt to travel to a state other than his or her state of residence or nationality for the purpose of perpetrating, planning, or preparing for or participating in terrorism or providing or receiving terrorist training. For any person to organize or facilitate the travel of individuals to a state other than their states of residence or nationality, knowing that such travel is for the purpose of perpetrating, planning, training, or preparing for or participating in terrorism, or providing or receiving terrorist training. For any person residing abroad who comes to the Philippines to participate in perpetrating, planning, training, or preparing for or participating in terrorism, or provide support for or facilitate or receive terrorist training here or abroad. So, providing material support to terrorists. Any person who provides material support to any terrorist individual or terrorist organization, association, or group of persons committing any of the acts punishable under Section 4 hereof, knowing that such individual or organization, association, or group of persons is committing or planning to commit such act, shall be liable as principal to any and all terrorist activities committed by said individuals or organizations. In addition to their criminal liabilities, he or she or they may have incurred in relation thereto, mamay they become principal. So you're just supporting, you just provide material support, arms, diba? Or money, or food, diba? However, there are exemptions. Humanitarian exemptions, syempre. Humanitarian activities undertaken by the International Committee of the Red Cross. Kahit Red Cross, bisan pito kalaban, they have to administer first aid, they have to administer medical support. The Philippine Red Cross and other state-recognized impartial humanitarian partners or organizations in conformity with the international humanitarian law do not fall within the scope of Section 12 of this Act. Kung taga-Red Cross ka, pero may nakita ka dito naghihingal nga terrorist, considered dito nga terrorist, and then you provided that terrorist with medicine, food, and medical attention, then you cannot be considered to be a principal to terrorism because it's exempted, no? The law, Section 13 of the law of the Anti-Terrorism Act of 2020 provides for such exemption. Accessory. Any person who having knowledge of the commission of any of the crimes defined and penalized under Section 4 of this Act without having participated therein takes part subsequent to its commission in any of the following manner. By profiting himself, herself, or assisting the offender to profit by the effects of the crime. For example, terrorism, sometimes they do kidnapping to fund their activities, diba? So, ano ito? By concealing or destroying the body of the crime or the effects of the instruments thereof in order to prevent its discovery. By harboring, concealing, or assisting in the escape of the principal or conspirator of the crime shall be liable as an accessory and shall suffer the penalty of imprisonment of 12 years. So take note, accessory, diba? It's still the same The same definition provided for in the revised penal code. However, the exemption to family members, no, is deleted. No, no person, regardless of relationship or affinity, shall be exempt from liability under this section. So if you are the parents of a terrorist and then you harbor your child, or you assist in the escape, or you assist in the concealment of the body of the crime, even if there is a relationship for purposes of the anti-terrorism law, the parents are still the ascendants, descendants, and collateral blood relatives are still considered to be accessories. The exemption provided for under the revised penal code is specifically omitted for this act. Imagine, no? So, Section 15, penalty for public official. If the offender found guilty of any of the acts defined and penalized under any of the provisions of this act is a public official or employee, he or she shall be charged with the administrative offense of grave misconduct and or disloyalty to the Republic of the Philippines and the Filipino people, and be meted with the penalty of dismissal from the service, with the accessory penalties of cancellation of civil service eligibility, forfeiture of retirement benefits, and perpetual absolute disqualification from running from any elective office or holding any elective office. Take note of that, no? Now, we have the wiretapping law, diba? Or Republic Act for 4200, 4200. However, again, the anti-terror law provides for an exemption to the coverage of the anti-wiretapping law. On general terms, you cannot wiretap generally. However, for purposes of the Anti-Terrorism Act, no, a law enforcement agent or military personnel may, upon a written order of the Court of Appeals, take note, ha, written order of the Court of Appeals, take note of this provision because this is a security provided for. Because if there's no such order, you cannot secretly wiretap. Okay, there should be an order coming from the Court of Appeals, and that such law enforcement agent can secretly wiretap over here and listen to, intercept, screen, read, survey, record, or collect with the use of any mode, form, kind, or type of electronic, mechanical, or other equipment or device or technology now known or may hereafter be known to science, or with the use of any other suitable ways and means for the above purposes. Any private communications, conversations, discussions, data, information, messages in whatever form, kind, or nature, spoken or written words between members of a judicial, between members of a judicially declared and outlawed terrorist organization. So when we say judicially declared, there should be a judicial determination that such organization is considered to be a terrorist group. B, between members of a designated person as designed in Section 3 of Republic Act 10168. Any person charged with or suspected of committing any of the crimes defined and penalized under the provisions of this act, provided, take note of the security, because here we have constitutional guarantees. So here, provided that surveillance, interceptions, and recording of communication between lawyer and clients, doctor and patients, journalists, and other sources, and confidential business correspondence shall not be authorized. So, the communication still between lawyer and clients, doctor and patient, journalists and their sources, and confidential business correspondence shall continue to be what? Considered to be privileged communication. Okay, so you cannot wiretap the conversation between the lawyer and the client. Okay, because these are exemptions provided, di ba, under the law. The law enforcement agent or military personnel shall likewise be obligated to file an ex parte application with the Court of Appeals for the issuance of an order to compel telecommunication service providers and internet service providers to produce all customer information and identification records, as well as call and text data records, content, and other cellular and internet metadata of any person suspected of any of the crimes defined and penalized under the provisions of this Act. Furnish the National Telecommunications Commission a copy of said application. The NTC shall likewise be notified upon the issuance of the order for the purpose of ensuring immediate compliance. So take note, there should be an order of coming or an order coming from the Court of Appeal. So you cannot do that unilaterally without the order of the Court of Appeals. Judicial authorization requisites. The authorizing division of the Court of Appeal shall issue a written order to conduct the acts mentioned in Section 16 of this Act upon filing of an ex parte written application by a law enforcement agent or military personnel who has been duly authorized in writing by the Anti-Terrorism Council. After examination under oath and affirmation of the applicant and the witnesses she may produce, the issuing court determines that there is probable cause to believe, based on personal knowledge of facts or circumstances, that the crimes defined and penalized under Section 4, 5, 6, 7, 8, 9, 10, and 12 of this Act has been committed, no? Or is being committed or is about to be committed. So again, these are guarantees. Take note, diba? Provided for in our Bill of Rights that there is probable cause to believe, based on personal knowledge of facts or circumstances, that evidence which is essential to the conviction of any charged or suspected person or to the solution or prevention of any such crimes will be obtained. The written order by the authorizing division of the Court of Appeals, as well as the application for such order, shall be deemed and hereby declared as classified information. Okay? Being classified information, access to the said documents and any information contained in the said document shall be limited to the applicants, the one who filed the ex parte application, duly authorized personnel of the Anti-Terrorism Council, the hearing justices of the Court of Appeals, the clerk of court, and duly authorized personnel of the hearing or issuing court. The written order of the authorizing division of the Court of Appeal shall specify the following: the identity, such as the names and address, if known, of the persons or persons whose communications, messages, conversations, discussions, or spoken or written words are to be tracked down, tapped, listened to, intercepted, and recorded. And in the case of radio, electronic, or telephonic communications, messages, conversation, discussions, or spoken or written words, the electronic transmission systems or the telephone numbers to be tracked down, tapped, listened to, intercepted, and recorded, and their location, or if the person of the or persons suspected of committing any of the crimes defined and penalized under the provisions of this Act are not fully known, such person or person shall be the subject of continuous surveillance. The identity of the law enforcement agent or military personnel, including the individual identity of the members of his team, judicially authorized to undertake surveillance activities, the offense or offenses committed or being committed or sought to be prevented, and the length of time within which the authorization shall be used or carried out. Okay, so the order should be very specific, okay? And should not just refer to any person. Kasi nga, if the identity of the members of his team uh, if the identity of the subject is not fully known, okay, such person shall be subject of continuous surveillance. It should be made known, okay? Section 19, effective period of judicial authorization. Any authorization granted by the Court of Appeals pursuant to Section 17 of this Act shall only be effective for the length of time specified in the written order of the authorizing division of the Court of Appeals, which shall not exceed a period of 60 days from the date of receipt of the written order by the applicant, law enforcement agent, or military personnel. So you cannot wiretap forever. 60 days lang to obtain the necessary information, the necessary evidence, which would be the basis of a conviction. The authorizing division of the Court of Appeals may extend or renew the said authorization for a non-extendable period. So it can be extended for a period of 30 days, but it's no longer extendable after that. That the issuing court is satisfied that such extension or renewal is in the public interest, provided further that the ex parte application or renewal is in the public interest, and provided further that the ex parte application for extension of renewal, which must be filed by the original applicant, has been duly authorized in writing by the Anti-Terrorism Council. In the case of death of the original applicant of the first motion, or in case he or she is physically disabled to file the application for extension or renewal, the one next in rank to the original applicant among the members of the team named in the original written order. Kasi take note, diba, the team members of the surveillance team should be indicated. Not everyone can actually participate because everything that will be obtained from here are considered to be classified. Okay? Provided finally that the applicant, law enforcement agent, or military personnel shall have 30 days after the termination of the period granted by the Court of Appeals as provided in the preceding paragraphs within which to file the appropriate case before the public prosecutor's office for any violation of the Act. For purposes of this provision, the issuing court shall require the applicant, law enforcement, and military official to inform the court after the lapse of 30 days of the 30-day period of the fact that an appropriate case for violation of this act has been filed with the public prosecutor's office. Take note, this one ha, any law enforcement agent or military personnel who conduct surveillance activities without a valid judicial authorization pursuant to Section 17 of this act shall be guilty of this offense and shall suffer the penalty of imprisonment of 10 years, may kunwari ka authority from the court, to wiretap, 10 years penalty. All information that have been maliciously procured should be made available to the aggrieved party. Okay? Section 25. Pursuant to our obligations under the United Nations Security Council Resolution number 1373, the Anti-Terrorism Council shall automatically adopt the United Nations Security Council consolidated list of designated individuals, groups of persons, organizations, or associations designated and or identified as a terrorist, one who finances terrorism, or a terrorist organization group. Request for designation by another jurisdiction of supranational jurisdiction may be adopted by the ATC after determination that the proposed designee meets the criteria for the designation of the UNSCR number 1373. The Anti-Terrorism Council may designate an individual, group, persons, organization, or association, whether domestic or foreign, upon a finding of probable cause that the individual, group, or persons, organizations, or association commit or attempt to commit or conspire in the commission of the acts defined and penalized under 4, 5, 6, 7, 8, 9, 10, 11. Actually, this provision of the law became very contentious. There were so many objections on this one because nga, the probable cause, the finding of probable cause. But later, I will discuss that. There's an explanation to that. This provision was actually upheld by the Supreme Court, meaning this provision of the law is valid. But anyway, it will be discussed a little later. The assets of the designated individual, groups of persons, organizations, or associations above mentioned shall be subject to the Anti-Money Laundering Council to freeze pursuant to Section 11 of Republic Act 10168. The designation shall be without prejudice to the proscription of terrorist organization, association, or groups of persons under Section 26 of this Act. Any group of persons, organization, or association which commits any of the acts defined and penalized under Section 4 to 12 of this Act, or organized for the purpose of engaging in terrorism, shall, upon application of the Department of Justice before the authorizing division of the Court of Appeals, with due notice and opportunity to be heard, to the group of persons, organization, or association be declared as terrorist and outlawed group of persons and organization of association by the said court. So they cannot be actually proscribed as terrorist groups, no, without the application of the Department of Justice to the Court of Appeals. So they are actually, these persons, individuals, are actually given the opportunity to be heard, to refute any allegations of terrorism activities. The application shall be filed with an urgent prayer for the issuance of preliminary order of prescription. No application for prescription shall be filed without the authority of the Anti-Terrorism Council upon recommendation of the National Intelligence Commission Coordinating Agency, which is NICA, where the court has determined that probable cause exists. So take note, has Section 7, it is still the court that will determine no probable cause. So did they ini na 25, upon finding a probable cause, the probable cause is determined by the court and not by the Anti-Terrorism Council. So that was the contention before, because it seemed like that the Anti-Terrorism Council was given the power to determine probable cause. But that's not actually what is happening here. You just have to proceed with the sections. It is written in section 27 that where the court has determined that probable cause exists on the basis of the verified application, which is sufficient in form and substance, that the issuance of an order of prescription is necessary to prevent the commission of terrorism, he or she shall, within 72 hours from the filing of the application, issue a preliminary order of prescription declaring that the respondent is a terrorist and an outlawed organization or association within the meaning of Section 26 of this Act. The court shall immediately commence and conduct continuous hearings which should be completed within 6 months from the application has been filed, to determine whether the preliminary order of prescription should be permanent. So this one, preliminary pala yan, temporary. Or a permanent order prescription should be issued in case that no preliminary order was issued. A preliminary order of prescription should be lifted. It shall be the burden of the applicant to prove that the respondent is a terrorist and an outlawed organization or association within the minimum of Section 26 of this Act before the court issues an order of prescription, whether preliminary or permanent. So the burden of proof actually is within the who? The burden of proof is within the law enforcement agents. No, the permanent order of prescription hearing granted shall be published in a newspaper of general circulation. It shall be valid for a period of 3 years, after which a review of such order shall be made, and if circumstances warrant, the same shall be lifted. Okay, detention without judicial warrant of arrest. This one also was considered to be a contentious provision. There were so many objections as well in this one. The provisions of Article 125 of the Revised Penal Code, to the contrary notwithstanding, any law enforcement agent or military personnel who, having been duly authorized in writing by the Anti-Terror Council, has taken custody of a person suspected of committing of the acts defined and penalized under Section 4, 5, 6, 7, 8, 9, 10, 11, 12 of this Act, shall, without incurring any criminal liability for delay in the delivery of detained persons to the proper judicial authorities, deliver such said suspected persons to the proper judicial authority within a period of 14 years. So 14 calendar, so not years. 14 calendar days, so take note, no. It goes against, diba, the 18-hour, 24-hour, and the 36-hour requirement. So 14 days. So that's the case. If that's the case, even there was delay, if there was delay in the delivery nga, based on the RPC, but for purposes of the anti-terrorism law, the the law enforcement agent shall not incur liability. The period of detention may be extended to a maximum of 10 calendar days if it is established that the further detention of the person is necessary to preserve evidence related to terrorism or complete the investigation. Further detention of the person is necessary to prevent the commission of another terrorism. The investigation is being conducted properly and without delay. Immediately after taking custody of a person suspected of committing terrorism or any member of a group of persons, organization, or association proscribed under Section 26 hereof, the law enforcement agent or military personnel shall notify in writing, take note ha, notify in writing the judge of the court nearest the place of apprehension or arrest of the following facts. Take note, the delivery of the arrested person does not have to happen within 36 hours, diba? It could be within 14 calendar days or an additional of 10 calendar days, but immediately after taking custody, the law enforcement agent must notify the judge of the court, notify in writing of the judge of the court nearest to the place of apprehension of the following facts. Number one, the time and date of manner of arrest, the location or location of the detained suspects, the physical and mental condition of the detained suspects. The law enforcement agent or military personnel shall likewise furnish the Anti-Terror Council and the Commission on Human Rights and the written notice given to the judge. The head of the detaining facility shall ensure that the detained suspect is informed of his or her rights as a detainee and shall ensure access to the detainee by his or her counsel or agencies and entities authorized by law to exercise visitorial powers over detention facilities. The penalty of imprisonment of 10 years shall be imposed upon the police or law enforcement agent or military personnel who fails to notify any judge as provided for in the preceding paragraph. Again, this is a guarantee provided for by the law itself so that the law enforcement agencies and the military personnel will also not abuse their power when it comes to detaining persons suspected to be participating in terrorist activities. Section 30, rights of a person under custodial investigation. So it's the same thing, to be informed of the nature and cause of his arrest, to remain silent, and to have competent and independent counsel, preferably of his or her choice. If the person cannot afford the services of a counsel of his or her choice, the law enforcement agent or military personnel concerned shall immediately contact the Free Legal Assistance Unit of the Integrated Bar of the Philippines or the Public Attorney's Office. It shall be the duty of the Free Legal Assistance Unit of the IBP or the PAO thus contacted to immediately visit the persons detained and provide him with him or her with legal assistance. These rights cannot be waived except in writing and in the presence of his or her counsel of choice. Inform the cause of or causes of his or her detention in the presence of his legal counsel. Allowed to communicate freely with his or her legal counsel and to confer with him at any time without restriction. So, pwede mag-meet with the legal counsel. Allowed to communicate freely and privately without restrictions with the members of his or her family or with his or her nearest relatives and to be visited by them, allowed freely to avail of the services of a physician or a physician of choice. Violation of the rights of a detainee. Take note, the penalty, again, mapaprison na liwat and law enforcement agent or military personnel who violates 29, and 30, no? Shall be punishable for 10 years imprisonment. Unless the law enforcement agent or military personnel who violated the rights of a detainee or detainee as stated above is duly identified, the same penalty shall be imposed on the head of the law enforcement unit or military unit having custody of the detainee at the time of the violation was done. So now, here, di ba? Now the problem here is that the head now, if it cannot be identified, no, who violated the rights of the detainee, then the whole team and the head will be made to suffer 10 years imprisonment. Imagine. So, no torture or coercion in investigation and interrogation. The use of torture and cruel, inhumane, and degrading treatment or punishment as defined in Section 4 and 5 of Republic Act 9745, otherwise known as the Anti-Torture Act of 2009, at any time during the investigation or interrogation of a detained suspected terrorist is absolutely prohibited and shall be penalized under said law. Any evidence obtained for said detained person resulting from such treatment shall be in its entirety inadmissible and cannot be used as evidence in a judicial, quasi-judicial, legislative, or administrative investigation, inquiry, proceeding, or hearing. So it's the same thing, the fruit of the poisonous tree. Restriction of the right to travel. So we have the liberty of abode, diba? The liberty of travel. But prior to the filing of an information for any violation, the investigating prosecutor shall apply for the issuance of a precautionary departure order. So you cannot go out of the country if you have a PhDO against the respondent upon a preliminary determination of probable cause in the regional trial court. So take note here again, the probable cause is to be determined by the regional trial court and not for any other persons. Upon the filing of the information regarding the commission of any acts defined and penalized under the provision of this act, the prosecutor shall apply with the court having jurisdiction for the issuance of a whole departure order against the accused. The said application shall be accompanied by a complaint affidavit and its attachment, personal details, passport number, and a photograph of the accused if available. In cases where evidence of guilt is not strong and the person charged is entitled to bail and is granted the same, the court, upon application by the prosecutor, shall limit the right to travel of the accused to within the municipality where he or she resides or where the case is pending in the interest of national security and public safety consistent with Article 3, Section 6 of the Constitution. The court shall immediately furnish the DOJ of the Bureau and the Bureau of Immigration with a copy of said order. Travel outside of said municipality or city without the authorization of the court shall be deemed violation of the terms and conditions of his or her bail, which shall be forfeited as provided for in the rules of court. Take note. So the bail is conditional. He or she may also be placed under house arrest by order of the court at his or her usual place of residence. While under house arrest, he or she may not use telephones, cell phones, emails, computers, the internet, or other means of communication with people outside the residence until otherwise ordered by the court. If the evidence of guilt is strong, the court shall immediately issue a whole departure order and direct the DFA to initiate the procedure for the cancellation of the passport of the accused. The restrictions above mentioned shall be terminated upon the acquittal of the accused or the dismissal of the case filed against him or her or earlier upon the discretion of the court and motion of the prosecutor of the accused. Now, Anti-Money Laundering Council authority to investigate. Upon issuance by the court of a preliminary order of proscription, in Article 25 and 26, the AMLAC, either upon its own initiative or the request of the Anti-Terror Council, is hereby authorized to investigate any property or funds that are in any way related to financing of terrorism as defined and penalized under the law, or property or funds of any person or persons in relation to whom there is probable cause to believe that such person are committing or attempting or conspiring to commit or participating in or facilitating the financing of the aforementioned sections of this act. The AMLAC may also enlist the assistance of any branch, department, bureau, office, agency, or instrumentality of the government, including government-owned and controlled corporations, in undertaking measures to counter the financing of terrorism, which may include the use of its personnel, facilities, and resources. For purposes of this section, and notwithstanding the provisions of Republic Act 1405, 1405, otherwise known as the law on secrecy, the bank secrecy law, no? And the Foreign Currency Deposit Act of the Philippines, the General Banking Law of 2000, and other laws, the AMLAC is hereby authorized to inquire into or examine deposits and investments with any banking institution or non-bank financial institutions and their subsidiaries and affiliates without a court order. Diba? Actually, because of the bank secrecy law, you cannot fully encroach upon the account of any person. But for purposes of this act, the AMLAC is empowered, no, to examine records, bank records. Authority to freeze. Upon the issuance by the court of a preliminary order of prescription in case of designation, no? Either upon its own initiative or request of the Anti-Terror Council, is hereby authorized to issue an ex parte order to freeze without delay any property or funds that are in any way related to financing terrorism, property or funds of any person or persons in relation to whom there is probable cause to believe that such person or persons are committing or attempting or conspiring to commit or participating in or facilitating the financing of the aforementioned section of this act. The freeze order shall be effective for a period not exceeding 20 days upon petition by the AMLAC before the expiration of the period. The effectivity of the freeze order may be extended up for up the period of 6 months upon order of the Court of Appeals, provided that the 20-day period shall be tolled upon filing of a petition to extend the effectivity of the freeze order. Okay? Malicious examination. This one naman. So now, kanina, it's for the accused. Oh, it's against the accused. Now, for the accused, any person who maliciously or without authorization examines, deposits, placements, trusts, accounts, assets, or records in a bank or financial institution in relation to Section 36 here shall suffer the penalty of 4 years imprisonment. So again, the constitutional guarantee is here, and the laws, of course, for the benefit of the accused, protects the accused from encroachment of his accounts if there is no valid cause without any authority. So, Section 38. No administrative, criminal, or civil proceeding shall lie against any person acting in good faith when implementing the targeted financial sanctions as provided for under pertinent United Nations security resolution. But the defense would be good faith. Kung may malice, what ito good faith? Diba? Because here, malicious examination. Bank official and employees defying a court order. An employee, official, or a member of the board of directors of a bank or financial institution who, after being duly served with a written order of authorization from the Court of Appeals, refuses to allow the examination of the deposits, placements, trusts, accounts, assets, and records of a terrorist or an outlawed group of persons, organization, or association in accordance with Section 25 and 26 hereof shall suffer the penalty of imprisonment of 4 years. The penalty of imprisonment of 10 years shall be imposed upon any person, law enforcement agent, or military personnel, judicial officer, or civil servant, who, not being authorized by the Court of Appeals to do so, reveals in any manner or any form any classified information under this Act. The penalty imposed herein is without prejudice, and in addition to any corresponding administrative liability the offender may have incurred for such act. Okay? Any public officer who has direct custody of a detained person under the provision of this Act and who by his deliberate act, misconduct, and inexcusable negligence causes or allows the escape of such detaining person shall be guilty of an offense and shall suffer the penalty of 10 years of imprisonment. Mhm. So the law does not only penalize the accused or the terrorist, but also penalizes the law enforcement agencies. Penalty for furnishing false evidence, forged documents, or spurious evidence. The penalty of imprisonment of 6 years shall be imposed upon any person who knowingly furnishes false testimony, forged document, or spurious evidence in any investigation or hearing conducted in relation to any violation under this Act. Okay? The Anti-Terror Council will be composed of the Executive Secretary as its chairperson, the National Security Advisor, who shall be its vice chairperson, the Secretary of Foreign Affairs, the Secretary of National Defense, the Secretary of the Interior and Local Government, the Secretary of Finance, Secretary of Justice, the Secretary of Information Communication Technology, the Executive Director of the Anti-Money Laundering Council, Secretariat as its member. The CHR shall give the highest priority to the investigation and prosecution of violations of physical and political rights of persons in relation to the implementation of this Act. Protection of the most vulnerable groups, there shall be due regard to the welfare of any suspects who are elderly, pregnant, persons with disability, women, and children while they are under investigation, interrogation, and detention. So that ends our discussion on the anti-terror law. No, I hope you learned something from the discussion. Next meeting, we will be discussing the juvenile justice, juvenile delinquency, juvenile justice and welfare act. Okay, in relation to children and their rights. Okay, so uh that ends our discussion for this morning. Next meeting will be a face-to-face class. Okay, so anyway, thank you so much everyone for bearing with me this morning. I have very limited connectivity, but next meeting we will see each other face-to-face for our second to the last meeting before your final exam. So anyway, I hope you are well. I hope you are healthy and safe wherever you are. For now, God bless everyone. I'll see you next week.